Kia ora and welcome to this very special programme broadcast from the Ministry of Business, Innovation and Employment. My name's Ian Kaplan and I open straight away with MB's Karakia. I do so now. Tawhia te mana, kia mau, kia maia, ka huri takuaru, ki te pai kahurangi, kei reira te oranga moku. Nā mahi tahi ka ora, ka puawai. A mātou mahi katoa, hono katika. Tihei mauri ora. Well, members of the audience, now we're together, and as I can see from the dashboard below, you are filing in virtually. A very warm welcome again. Some of you may know me elsewhere from the insignia behind me from GREG, the Government Regulatory Practice Initiative. This is actually an independent project, but supported by GREG, produced by MB. But if you're a regulatory practitioner, policy practitioner, or any kind of practitioner within government that's connected with the business and the question of making laws work better, then this is very much the programme for you. And that's because we're looking at the questions of what makes laws really work effectively and indeed what doesn't, what has the opposite effect. And to help us with that, we're really lucky. We're very lucky enough indeed to have a Court of Appeal judge, Justice David Goddard from the Court of Appeal of New Zealand, who's going to be talking about making laws that work, both in the sense of that very important question to us and also the title of a book and a website which the judge has produced on the subject. So what does a venomous snake and houses with too many windows have in common? You may well find out directly or perhaps as a sequel piece in terms of the materials, but they both relate to laws that didn't work. Now, just very, very quickly, because I'm going to hand over straight to the judge, you will have an opportunity to ask questions of the judge. And if Zoom is new to you, on the bottom of the dashboard, there's a Q&A function. Feel free to lodge the questions or indeed comments as the judge presents, and we can scoop them up as time permits afterwards. Also, it's not rude to talk to each other by way of chat. You're all here with a like-minded interest in this really important subject. So open fire with the chat function as you see fit. And if you want to emote, I'm not sure we have the emote function here, but if we did have the emote function, you can ventilate your emotions accordingly. So we'll hear about this important subject from Justice Goddard, who was formerly special counsel at MED, MB's predecessor, and also one of the few barristers in New Zealand history to effectively leapfrog, be promoted straight from the bar to the Court of Appeal. So we've got a bit of a coup, if I can say so, members of the audience. And I'll say, Your Honour, kia ora, a very warm welcome to you, and indeed, over to you.
Kia ora, Ian. Thank you for that overly kind introduction. Tēnā koutou, tēnā koutou, tēnā tātou katoa. It's a huge pleasure to be speaking to you today. As Ian said, among the various windows I've had the good fortune to have on the law over the last 40 years or so. One of the most enjoyable was the time I spent as a public servant at MB, as it then wasn't, working with some really wonderful people like Mark Steele, like Peter Mumford and others, and with Julie Nind, although she wasn't then at MED, she was in fact in the Ministry of Justice, but another very close colleague. And I just learned so much from that work. I've been a public servant, I've drafted legislation, I've drafted treaties, I've negotiated treaties, I've advised governments in other jurisdictions on law reform. I've been an arbitrator, I've been a barrister, and now, still slightly to my surprise, I find myself as a judge. So I've engaged with legislation in many, many different ways. And what I think all of you will be familiar with is first that there is a constant stream of legislation produced by various lawmakers, by Parliament, of course, but also by the executive in the form of regulations and various kinds of rules, by other rule-makers, agencies, by local government. And experience teaches that that legislation has mixed results. We've all had the experience of working on very successful projects that have flowed from the policy development process through making the legislation, into implementation and have achieved the objectives that prompted the whole exercise, that were the reason why it began, our policy goals. But experience also teaches that all too frequently legislation doesn't succeed in achieving its objectives. I've seen over 40 plus years, many failures. And the thing that started this project was really that I found myself seeing the same mistakes being made time and again in New Zealand and elsewhere, in rich countries and less wealthy countries. I realized that I was making the same mistakes, the same optimistic assumptions that didn't bear fruit again and again. And it seemed to me that it was time that we legal designers took a leaf out of the book of industries, areas of human endeavor, like aviation, like medicine, that take failure, that take adverse outcomes seriously, and that we paused and thought about them for a bit and tried to learn from them so that we stopped making the same mistakes. And so I thought I would write a book that, perhaps slightly depressingly, took as its starting point failure. Now I'm going to attempt to share my screen, and there's always this slight moment of anxiety when one engages with these things. Can I just check that that is working? Yep, that's working. So this was the ultimate product of those endeavors, a book on making laws that work, how laws fail and how we can do better. I've been thinking about this project for more than a decade off or on. I wrote the introduction several times, mostly on planes because no one could disturb me there, but it never got any further. So I decided if I was serious about doing this, and actually serious not just about collecting some anecdotes from my own experience, but drawing on a wider, properly researched pool of information, I needed to take some time to focus on it. So I took a year out of my then practice as a barrister and spent a year at NYU, New York University, as a fellow from practice and government in 2018-19, and did most of the work for the book there. And I finished it over the last few years on the edges of this slightly unexpected detour into life as a judge. In writing it, I should say, again, I benefited from the kindness and generosity of time of friends and colleagues, including Julie and others, who read drafts and gave me comments. But as always, and especially, I suppose, in a book about mistakes, the mistakes are my own. And I should begin by discussing one possible mistake. I talked about this at the Bar Association's annual conference recently, and the first question I was asked was, what's with the cover? One of the delegates had taken it down to breakfast to show her colleagues, and they'd all said, ugh, I don't want to see that over breakfast. It's gruesome, put it away. And I have to say, I've had slightly similar reactions from a few other people. Anyway, the theory behind this is that this is a very famous Rembrandt painting, The Anatomy Lesson. And the idea is that what this book is an autopsy of failed laws. We're going to dissect them to learn what went wrong and to avoid repeating the same mistakes. So that was the idea. Whether it was a good idea or not, I'll leave it to you to judge. So we should learn from failures, our own and those of others. My mum was a language teacher, and she used to say to her pupils and to her 4 children quite often that you should love your mistakes. You should love your mistakes, Mum said, because they're such great learning opportunities. Now, it's actually quite hard to love your own mistakes, but I do think it's useful to be on speaking terms with them so that you can engage with them and learn something from them. And I'll talk later, as long as I get my timing right, about one thing that I think I got wrong as a young drafter of companies legislation in my 20s, and I ended up talking to a select committee about how to fix some 20 years almost down the track. It's much easier to love and learn from the mistakes of others. And in a way, my book is a collation of other people's mistakes, things that have gone wrong elsewhere, from which we can learn so we don't have to make those mistakes ourselves. Basic structure of the book is it looks at 4 broad ways in which laws fail. I'll go through those, some common causes of those failures, and then critically, some suggestions to reduce the risk of failure in the future, some key issues to consider, some options for addressing each of those difficult issues, and some checklists. The book contains some checklists which are intended to ensure that in a systematic way, we think through some of these hard issues. Along the way, I will talk about what happened to this building. For now, just notice, and Ian mentioned this, the fact that in a number of places where clearly windows ought to be, there are bricks, painted over bricks. This is an English city. It's Portland Street. And we will talk about why it happened. We will also cover what these 3 animals have in common: rats, cobras, and feral pigs. And we will, as I say, begin all of that by talking about the 4 broad types of failed law: damp squibs, overshoots, nasty surprises, and backfires. First, damp squibs. Now, a squib traditionally is a little firecracker. The idea is that when you light it, it goes zzz, and then bang, it goes off. It's the point of firecrackers, right? But if they're damp, what happens? Nothing. And those of you who are familiar with the Harry Potter books will know that the very unkind label that's attached to people from wizarding families who can't do magic is squib, because magic doesn't go off. So the first type of failure is the damp squib. The legislation that sets out to achieve something but doesn't. It has basically no effect. These are extraordinarily common. I could take the whole of the rest of the seminar just talking about these. That wouldn't, but let's just pick 2 of my favourites. The first is the UK Proceeds of Crime legislation enacted in 2002. That legislation established an assets recovery agency, which proceeded to recover almost nothing, less in fact than its year-on-year operating costs, before being abolished in 2008. So the idea when this was initiated was that it would strip criminals of the proceeds of their criminal activity, thus deterring criminal conduct, ensuring that people did not in fact benefit from it, that the social goal of depriving criminals of the gains from their unlawful activity was advanced. And it was also expected that it would pay for itself and generate significant additional resources to support criminal enforcement activity. None of those goals was achieved. And we might talk a little bit more about why later. Another example, closer to home, is our relationship property economic disparity regime. They've got the relationship property legislation, which provides for the division of relationship property where a couple separates. Generally, I'll talk about this more later too, on a 50-50 basis. Courts held that income earning capacity of one party isn't property. So if what happens in fact is that the couple, rather than investing in assets, invest in one partner's future. One person works in a low-paid job while the other goes to medical school. One stays home and looks after children while the other goes to medical school, or advances as a lawyer or an accountant, becomes a partner, builds professional networks. When they separate, it turns out that that much enhanced income earning capacity of one partner isn't property, can't be taken into account in the division of relationship property. This can produce has in many cases produced significant unfairnesses. So legislation was enacted to address that. However, and it was expected that it would be a big deal. There were debates in Parliament. Some people think it would be wonderful. Others think it's going to be the end of the world. The principal family court judge appeared before the select committee considering it to say that it was going to be enormously demanding for the courts and that 6 full-time family court judges would be required just to deal with economic disparity work. Didn't happen. In fact, some years there's no reported final decision on an economic disparity issue. 1 or 2 a year is more normal. Why? Well, because the legislation contained a very broadly framed standard for when an award could be made and what would be awarded. The courts approached it in a way which was very conservative and very, very complicated. In order to succeed in an economic disparity claim, you needed to call expert evidence about the career you would have had if the division of functions in the marriage had not resulted in you staying home, for example, to look after children. And then the other side would call experts to say, no, your qualifications weren't that great, you had all these personality flaws that meant you probably wouldn't have succeeded. It was not only enormously complicated with HR experts, economists, also accountants, but it was a very demeaning and problematic approach. And when you got across all these thresholds, the awards that were made were modest. You know, the 50-50 sharing of relationship property might be tweaked to the person getting an extra 5% or 10%. And if the pool of property is not that large, it's not much of a payback for all that cost and risk and delay and uncertainty. So the legislation is today essentially a dead letter. That's often the case, and I'll come back to this too, where low value claims, as most of these are, must be pursued through formal legal channels before obtaining any recovery. That is, where the default outcome is no remedy unless and until you actually get before a judge and get a final decision. As will become clear in the course of this seminar, I hope, I think that courts are an incredibly important last resort, but they should generally be a last resort. And to frame laws that require people to go to the court to get remedies in the context of modest value claims is effectively to consign those rights, consign those entitlements to the rubbish bin. And that's basically what has happened here. So what are some causes of damp squibs? One depressingly common cause is that the people to whom the law is addressed, the people it's intended to benefit or who are expected to comply with it, aren't aware of it or don't understand it. Posting legislation on the PCO website is incredibly important in terms of access to law, but that does not mean that every New Zealander will be aware of it, will understand the benefits it provides to them, the obligations it imposes on them. When I talk about this, and I say, imagine going out into the street and saying to people, "You've got a car? Yep. When did you last read the Land Transport Act?" You've got a job, you pay tax. When did you last read the Income Tax Act? Now, this rhetorical question doesn't work so well in Wellington. So you go out in the street and you ask a passerby, "Oh, when did you last read the Income Tax Act?" And I was like, "Well, I've never read that." Well, actually, I'm just working on a review of the accrual rules at the Wellington's the wrong place to ask this question. But in most normal cities, the answer is that people have not read any of the legislation that affects their daily lives. How are they aware of it? All too often, they aren't. And if they aren't, it's not going to affect their behaviour very much. People intended to benefit don't have the knowledge, skills, and resources required to obtain those benefits. People required to comply don't have the knowledge, skills, and resources to do so. If you say to small businesses that you need to store hazardous chemicals, for example, in a manner that ensures that all reasonable steps are taken to reduce risk of harm to people or the environment, most small business owners have no idea what's involved. You need to give them the tools to comply. Sludge is another problem. This comes from a wonderful title of a book by Cass Sunstein, brilliant American lawyer and writer, academic at Harvard. Queues, delays, complicated forms and processes, and other practical difficulties in accessing the benefits the legislation is intended to provide. Another very common barrier, institutions that lack the resources or will to administer the legislation. Another problem, less common, but really significant where it does exist, deep-seated beliefs or customs. Just passing a law won't change those. You need to invest in education. There needs to be leadership from key members of the community. There need to be a whole range of mechanisms to shift those behaviours. And one that's all too common, gains from breach outweigh sanctions. That can be an initial problem in an area. Now, we haven't got time to talk about deterrence and where that does or doesn't work today across large swathes of the criminal law. In fact, the evidence is that deterrence is largely ineffective. But in various regulatory and commercial spaces, the sort of spaces that MB is concerned with, there is evidence to support the effectiveness of deterrence in some contexts, but you've got to get it right. The deterrent has to be proportionate to the benefits from breach. Sometimes we don't even get that right initially, but the other huge problem in New Zealand is that New Zealand, relatively unusually internationally, puts fixed maximum penalties into its legislation and doesn't have any mechanism for indexing those. So over time, penalties that began as realistic ones cease to be. I picked two of my favourite examples from our statute book, things that are currently in force, that illustrate that rather nicely. I think the Taranaki Botanic Garden Act 1876, which provides for bylaws to be made imposing behavioural restrictions on what you can do in botanic gardens in Taranaki, and penalties, and the fine for breach of the bylaws, it says it must not be less than 10 cents. So you're not going to get away lightly with this, right? It is not going to be less than 10 cents and not more than $10. So also it's not going to be too onerous. In fact, I think it's fair to say that no one who was minded to do something unacceptable in a botanic garden is going to be put off from doing that by the risk of a fine that ranges from 10 cents to $10. The numbers were more significant back in 1876. It hasn't shifted since. There has been some inflation. The Impounding Act 1955, a slightly more contemporary example. When that was first enacted, the penalty for allowing stock to stray, among other offences, was set at $500. It remains at $500, and a figure that, if you adjusted it for inflation today, would be more than $13,000. Now, if that was the right range of penalties in 1955, certainly isn't today. And a little illustration of the importance of regulatory stewardship and paying attention to these things, unless and until we do the sensible thing and come up with some sort of indexed penalty unit, fine unit regime for New Zealand. Failure type 2, the overshoot, the too much ice cream problem, as I like to think of it. Good thing in moderation, not to. Again, one very depressing example because of the human cost involved, the 2013 bail law changes in New Zealand. These did in response to some very high profile and very terrible events where defendants on bail committed further serious offences. In one case in particular that prompted this, a murder while on bail. The law was changed to reverse the onus, to provide that instead of the prosecutor needing to establish that the person was a flight risk or was likely to commit serious offences while on bail or was likely to interfere with witnesses. Those are the three reasons why you might not give someone bail while they waited for trial. Instead of the prosecution having to show that these risks were present to an extent that justified incarcerating the person, imprisoning the person until their trial, the onus was shifted. So certain categories of defendant would be remanded in custody, would stay in prison, unless they could establish that those risks did not exist, and unless they could show that they had satisfactory accommodation at which to reside while they were on bail. Problem is, it turns out that it's very hard for people with limited resources, limited access to legal advice, especially limited English, to meet those tests. So having changed the default from bail to remand in custody, the default proved much stickier than expected. If you look back at the RIS, the regulatory impact statement, Justice estimated that there'd be a roughly 50-person increase in the number of people in prison at any given time, which was the point, right? A small number of high-risk offenders were supposed to be in prison, not on bail. So it was always expected that around 50 people would be in prison. The result's quite hard to measure, but remand rates increased by more than a third. And that probably added hundreds, and arguably, I think, over 1,000 extra remand prisoners every year. We currently have more than 4,000 people on remand in our prisons. At one stage, it was heading towards 5. And a lot of that, maybe, certainly I think 1,000 of those prisoners are likely to be there because of this shift in rules, coupled with the unexpectedly sticky nature of this default. Very high human and economic costs, especially for the worst off, and it appears from the figures, especially for women, the majority of whom, after being remanded in custody, do not in fact receive a custodial sentence. They should never have been in prison at all. That's quite shocking, I think. Way overshot. Another example, which will be familiar to some of you, the CCCFA responsible lender regime, which was strengthened in 2021 to deal with concerns about lenders in particular dealing with vulnerable borrowers, but which had a much broader impact than intended. It introduced delays in the lending process. It resulted in very intrusive inquiries into people's finances and spending, and it the general view was that it resulted in a number of creditworthy borrowers being denied lending. But the happy ending to this, and I'll come back to this, is that this was adaptive legislation. The problematic provisions were not hardwired in primary legislation. It's a nice piece of legislative design work. Whoever was responsible for that may be out there in the seminar. And it was possible to solve this issue swiftly by amending regulations and the responsible lending code. The new regime came in, I think, in December 21. By March this year, the minister was able to say there have been some unexpected consequences, unintended consequences. He was quoted by Radio New Zealand as saying, and by July this year, that had been addressed. So, nice piece of design, good illustration of something I'll be encouraging later. Some causes of overshoots: poor quality information and assumptions about current facts, a readiness to legislate without more fact-finding. There's too much of that. Sometimes it's not infrequently driven by the imperatives of the short electoral cycle in New Zealand, a minister's desire to get things done. There can be other reasons for it. I talk a bit about how to manage some of those issues in the book. Another common problem: overbroad application of rules, and a failure to provide for adaptive exclusions from those rules, so that if you realize they've overshot, you can claw some of that impact back. Changing default settings without addressing the stickiness of defaults, that was the 2013 bail law example. And critically, of course, failure to monitor outcomes against original goals and adjust in light of experience. Now, when what you're doing is affecting the ability of a reasonably articulate group of middle earning working people to borrow to buy homes, you don't need to do too much monitoring of outcomes. They'll talk to the media will tend to write it up and get big stories. If the problem is that the least advantaged groups in New Zealand are being disproportionately remanded in custody, much less likely to see any media coverage. Same is true of many other issues in relation to the regulatory context. The agency responsible for the legislation needs to monitor, needs to reappraise. Failure type 3, nasty surprises. Okay, the answer to slide 4, what happened to that building? The answer is the window tax, introduced in England in 1696. Before that, there'd been a half tax. You were taxed on the number of fireplaces you had in your house, but that caused a lot of friction, not least because the tax collector had to enter your house and inspect every room and count the fireplaces. And there were quite a lot of issues with people not being allowed in, and violence and things like that. So someone had the bright idea, well, let's tax people by reference to how many windows a building has, because you could check that from the outside and it's a roughly progressive tax because the wealthier someone is, the bigger the building, the more the windows, especially in those days when glass was expensive. So window tax was introduced, and for a little while it did raise a lot of much needed revenue. But no one likes paying taxes. That is true today, it was true in 1696. It's probably an oversimplification. Actually, some people welcome the opportunity to bear their share of the cost of living in a modern society, but a lot of people are unenthusiastic, it would be fair to say, about paying tax. So what happened over time? Well, new buildings were built with fewer windows because that meant that the ongoing ownership costs were lower. And existing buildings had windows bricked in to reduce the ongoing tax burden associated with owning that building. And that's what happened to that building we saw. Someone built it with lots of windows. Subsequent owner decided they were unhappy with the tax burden that carried, and they bricked them in, reducing the amount they had to pay year on year. Now, tragically, this coincided with the Industrial Revolution and with the flow of people from the country to the cities, to tenement buildings, which were run up quickly to house all these people who moved there with, because it was cheaper, very few windows. The result was lack of light, lack of air, significant health impact, significant deaths. This was an issue that was identified within 50 years of the tax being introduced, but it was finally called out vigorously by Charles Dickens in a magazine that he started called Household Words in 1850. And he wrote in that, in an editorial, that the adage free as air has become obsolete by act of Parliament. Neither air nor light have been free since the imposition of the window tax. He went on to talk about the problems this was causing in terms of health. It was an important part, I think, of the ultimate repeal just 1 year later of the window tax in England. Meanwhile, however, and in my book, I talk a little bit about when we should follow overseas legislative models and when we should be cautious about this. Without inquiring into or understanding these adverse consequences of the tax, it had been copied in France and the Netherlands and several other European countries, and some of which it lasted even longer. The last vestiges of the window tax didn't disappear in France until into the 20th century. So, and the health consequences for many people over more than 150 years were very significant. Pretty nasty surprise. The leaky building crisis in New Zealand, an entirely desirable, in many ways, move from highly prescriptive regulation of the building industry to performance-based regulation. But without the skills and resources needed in the building industry, in the more than 70 at the time local authorities throughout New Zealand, some very small, and certainly not in the Building Industry Authority, the BIA, because it was incredibly badly resourced, incredibly inadequately resourced at the time. And that's even without getting into things like building certifiers. The net result was, as we all know, huge numbers of buildings throughout New Zealand, mostly, but not only homes, with weather tightness issues, costs, remedial costs estimated at in excess of $11 billion. Huge cost to a small country as a result of poor regulatory design, poor legislative design. A common nasty surprise is implementation costs far in excess of predictions. That can result either in a damp squib, if the funding available is capped, so you just don't get very much of what you wanted, or a nasty surprise if there's no effective budget cap. Think remanding people in custody. Judges don't make those decisions based on how much the total expenditure is going to be. You end up with a nasty surprise in terms of what the overall cost to the public purse is. Some causes of nasty surprises: static analysis, failure to think through incentive effects. It's the window tax issue, yeah. Short run, yes, you collect tax on the windows that exist, but long run, fewer windows, less tax, and other adverse effects. Lack of institutional capacity or will to administer the law in accordance with its objectives. Capacity tends to be more of an issue than will in New Zealand, but in some other countries, both are a very significant problem. and a lack of focus on whether and how those people to whom the law speaks can do what it requires. Failure type 4, backfires. Here we get the what do those three animals have in common answer. And this is, I think, my favorite example of a failed law. This comes from Bombay under the Raj. The British governor became concerned about the large number of poisonous cobras in the city. Poisonous cobras, not a good thing. And thought, well, I'll issue a proclamation providing for a bounty on cobra skins. You bring me a cobra skin, you get paid a very small amount. Problem was that some enterprising locals realized that it's not actually very difficult to breed cobras. So around the edges of the city, all these cobra farms sprang up. People bred the cobras, they killed the young cobras, they took in the skins, they got the bounty. What happened? Well, large sums were spent on the bounty, but in the city itself, there were no fewer cobras because people weren't catching the wild ones because that was much harder than raising your own, having them in an enclosure and leaving them to breed. So the governor cancelled the bounty. Now, if you were a cobra farmer, if you had a ramshackle shed out the back of your property full of poisonous cobras that you've been raising in order to kill them and had in the skin, and then the revenue stream was cut off, what would you do? Well, answer is you open the door and you release the cobras because they're no use to you anymore. You don't want to be feeding them. You don't want them on your property. You hope they'll slither away and head off into the city. And so they did, with the result that there were, in fact, more cobras than before. Because you had not only the wild ones, but all the ones that had been bred, fed, carefully looked after, tended, and released when the bounty disappeared. This is such a famous example among economists. It's actually known as the Cobra effect, this sort of backfire, after a book by a German economist, Die Cobra Effect, describing it and some other similar failures. Now, you might think this is a quirky historical example of the kind that you wouldn't experience very often. But no, 300 years later in Hanoi in the French era, roughly the same happened, but with an extra twist. There was a problem with rats in Hanoi. And when the French colonial administrators built these beautiful modern sewers flowing from the beautiful colonial villas, many of you visited Hanoi, you'll know there's wonderful villas in the center, out away from that part of the city. Turned out those were motorways for rats to come in. So you had lots of rats in the French quarter in Hanoi. So the governor thought, well, we'll pay a bounty on rat tails. Again, turned out it's very easy to breed rats. Lots of people started farming the rats. Much easier to breed them than catch them. And it also, people realized that if you do catch a wild rat, if you cut off its tail to claim the bounty but let the rat go, it will breed more little rats, which provide more bounty opportunities in the future. So it's a mistake to kill them. The net result was the bounty proved very costly and expensive. It was cancelled. All the rats in the rat farms around the city get released. More rats in the city. And from, you can see from magazine articles, and which I found online from the time, many sightings of tailless rats. Beaucoup de rats sans queue. It's, very, very odd. Why are suddenly all the rats in the city tailless? And just to prove that it's not just colonial administrations in distant lands that have this problem, as recently as 2007 in Fort Union, exactly the same thing happened this time with wild pigs. People weren't breeding them, but they were feeding them, attracting the feral. This was a military base. They ended up with people feeding them to attract them into the base so they could then kill them and claim the bounty there. There are many other depressing backfires around the world. They're particularly common, depressingly, in the context of environmental regulation. One more example, then I must press on. The example comes from Mexico City. Mexico City has a major smog problem, and a large contributor to the smog is vehicle exhaust fumes. So, back in 1989, Mexico City introduced a carless days scheme. It was tied to your number plate. If your number plate ended in 0 or 1, you couldn't use the car on Monday. 2 or 3, Tuesday, and so on. So for every car, there was one working day in which you could not use the car. This, they thought, would mean that 20% of cars were off the road on any given weekday. Didn't work. Why didn't it work? Well, because many households, not the very poorest, but then a lot of them didn't have cars anyway, but many middle-class households bought a second car. And importantly, you concerned not only with the make of the car and its colour, but also its number plate. It needed to have a different number from your existing car. And because these were second cars, mostly they were cheaper and therefore older and therefore more polluting than your existing car. So on the days when you couldn't drive your more modern, less polluting car, what you drove instead was the older, more polluting car on all the same journeys that you would otherwise have taken. And as any of us who have lived in households with more than one adult or adult children know, if there's 2 cars available to be used in a household, a lot of the time people will use both cars. So not only were these second cars being used on the days where the main car was off the road, but they were being used on all the other days as well, except their one day off. So actually what happened was more cars on the road, much more pollution. A number of really good, really rigorous studies showed that this initiative had increased air pollution, increased congestion in Mexico City. Despite this, there are a lot of other cities that have tried similar initiatives. New Zealand had its own variant of this, of course, the carless days back in the 1970s, early 80s. And we see this play out in a number of other areas. It turns out that setting a minimum threshold standard on environmental emissions, for example, or vehicle safety or something like that, and then grandparenting all the existing non-compliant cars or factories or whatever will often produce similar outcomes. Causes of backfires then, static analysis, failure to think through the incentive effects. That's really the problem with the cobras, rats, pigs, grandparenting of existing approaches, and lack of institutional capacity, or well, I haven't got time to dwell on that because time is getting tight. So, pressing on, some key themes from the study of failures. First, law is not magic. You can't just pass an act that says COVID-19 is hereby abolished, or poverty is hereby abolished, or educational attainment is hereby increased by 10%. None of that works. Laws can only work by changing how people behave. Now, it just seems so obvious, but it's actually the thing people forget to focus on time and time again. If laws only work by changing how people behave, then when you're designing a law, that means you've got to work out who your audience is, who you are speaking to, whose behavior needs to change, and ask, how will they know what to do in response to this law, and how easy is it for them to do what the law requires? You need to be clear on the policy goals. You need to be clear on how people behave now. You need a rich understanding of what they do and why. You need a clear understanding of what it is that's unsatisfactory about that. What is the policy problem? What do we want to change in terms of how people behave? Which people? What do we want them to do? What does success look like? What differences will we see in relevant actors' behavior if the law succeeds? And then some critical questions. Can the legislation bring about these changes in behavior or contribute to them? Often won't be the whole of the answer, but what is our theory of change? Why do we think that if the legislation is passed in this form, behavior will change in that way? And very, very importantly, how sure are we about that? How much uncertainty is there around those outcomes? What all of this means is that we need to pay close attention to the quality of the information available to us, do our best to enhance that quality of information, and we need to pay attention to uncertainty and its implications. We also need to really be very, very focused on unpacking our reasons to legislate. Sometimes people say, well, the goal of this legislation is to change the law from X to Y. That, it seems to me, is just about the silliest reason to legislate, put in those terms that there can be. Who cares? A few nerdy lawyers might care about what the law says on paper, but basically what we're interested in is how our society operates, on the well-being of people, on the state of the environment, on certain other, policy goals, not on the law on paper. So let's describe reasons to legislate in those terms. I also get frustrated with statements about, oh, we're doing this to make the law fairer, because fairer on paper is irrelevant if very few people can access the benefit in practice. I think the economic disparity legislation was a great example of making this mistake. There was a huge focus on making the law fairer, on ensuring that the law addressed this problem, and insufficient focus on asking, how will this translate into outcomes for people on the ground? Another one you hear is, well, we're not satisfied with the outcomes we're seeing in court proceedings. We want different, fairer, better outcomes in court. But again, it's only a tiny number of people, usually the best resourced and most litigious, who end up in court or who can credibly threaten to do so. Take relationship property. I tried to crunch some numbers as best I could in the book. I think that less than 2% of relation property divisions are decided in the courts. That is, of the couples who separate in any given year, fewer than 2% end up having the sharing of their property determined by the family court or by some other court on appeal. What that means is that fairer outcomes for them in court only applies to them and a small number of others who bargain in the shadow of the law. But they bargain in the shadow of the law only if one or other, only if both actually, can credibly threaten to go to court if a satisfactory resolution is not achieved. I am being told that I have less time than I thought I had actually off screen, so I'm going to have to move very fast, and I might steal 2 more minutes. If you're interested in outcomes for some defined group, be clear about who that group is, who will behave differently, and what are the goals in terms of breadth of breach. For example, relation to property legislation, is the goal that all separating couples will divide their property fairly, most, half, or as I think is probably the case now, the fewer than a quarter, when you look at census data about household wealth, for whom the law is actually directly relevant. I'm very tight on time. I have to say I have been over-optimistic again. You'd think I'd learned from my mistakes, especially given the topic. But the key point is that people are not very good at making predictions. We're very good at making up stories that explain the present and predict the future, but these stories are often wrong. There's a huge amount of research that is done on this in the psychology of human decision-making that confirms this. Experts are slightly better at making predictions and much, much more confident. Tragically, however, there is no correlation between the confidence we feel and the accuracy of our predictions. There are strategies for improving the quality of our predictions, but they'll still be pretty imperfect. In the book, I explore 2 strategies for reducing the risk of failure. One is adopting a more structured and systematic approach, breaking big questions down into more manageable sub-issues, gathering information, drawing on a range of perspectives. Broad teams are important, broad consultation, extremely important. And not just by publishing something and asking for a response. You've got to get out there, get your hands dirty, suck the information in, not just wait for it to come to you. And use techniques to improve reliability of predictions. And then critically, bear in mind what you don't know about the world as it exists now, and the certainty of unexpected developments over time. And what that means is that we need to design laws to enable us to respond to new information and to changes in circumstances. We need adaptive legislation. I'm going to talk about one more thing, and then I'm going to talk about the things I'm not going to talk about. I can't emphasize too strongly that what is critical is the user interface for a law. The law on paper is important, but most people affected by a law will never read it or seek legal advice about it. So how will they know what they need to do? We'll say the answer is a bit like the code on your phone, right? We don't need to know what the code sitting underneath our iPhone is because we have hardware. My daughter with a Pavlova beta. We don't need to have an understanding of that code because we have a user interface that makes it simple for us to interact with it. And legislation needs to be the same. And we can't design the code without thinking about the user interface. They're intimately linked. Policy people, operational people need to work together hand in hand from day one to understand what the law and its user interface will be so that we can answer questions like, who will be able to access this? Who will be able to comply with it? How will they know what they need to do? Will they be able to do it? Now, there's so much more I could say, but if I try to say it, I will be physically turned off. So I will just flag the importance of default settings, incredibly important. And you can do that either with a hardwired default or a permanently binding decision. We do this very well in the child support space in New Zealand, I think, with an initial formula assessment, then a review on some dimensions by an official, and then a broader review, if necessary, by a court, which means that unlike many other countries, we have to get to court and get to a judge before you get any child support. Here, an estimate of the amount is flowing, and only a tiny number of cases need to go through the slower, more expensive court option. Adaptive legislation is incredibly important, and I spend some time in the book looking at the many different forms that adaptive legislation can take. And I'll just let you look at those for 2 seconds, and the slides will be made available, I should say, so you'll be able to have a look at these in more detail. But there's many, many ways in which you can ensure both that legislation can respond to new information and to changing circumstances, while at the same time providing people with a significant level of guidance. And lastly, I'm going to talk about not talking about complexity and reducing complexity. One of the basic themes of my book is that the complexity that matters is complexity experienced by the user. A standard that seems very simple on paper may be very complex for users to apply. Conversely, monstrous laws, horrible, long, fine-grained laws like the Income Tax Act may be very simple for users with the right interface. Most of us don't need to understand it or do anything about it because we can simply have tax deducted from our income at source, PAYE, and then now you don't even usually need to file a tax return. Again, institutions are critical. There are many complexity reducing mechanisms that can be provided for in legislation if it's well designed and if policy teams, operational teams work together to make it work. Choosing an approach is critical. It depends on audiences, frequency with which the issue arises, and institutional arrangements, among other things. My suggestion is that we should generally strive for the greatest level of accessibility and predictability for users that is reasonably achievable. And there are a range of ways we can do that. I was going to talk about Companies Act minority buyouts. The company law nerds out there, I'm sorry, that's not going to happen at all. This is a good example of a general provision which looked simple on paper, fair and reasonable price, turned out to be a nightmare to apply in practice. I was the drafter for the Law Commission who wrote that in response to rather general instructions, it would be fair to say. It didn't work very well. In 2008, it was amended to provide a default valuation methodology and a safety valve that you can depart from it if it would be clearly unfair to the shareholder of the company. It turns out essentially the same test, but with a default and a carefully circumscribed level of stickiness from moving away from it worked much, much better. And if you're going to achieve the more refined outcome that I was able to advocate for before a select committee in 2008, rather than the unsatisfactory, unstructured outcome that I drafted as a 26-year-old drafter in 1989, then you might find it helpful to look at my checklists, the primary checklist, and these will also be made available, I should say. I provide copies of these in case they're useful to you, which go through 10 key questions to ask about any project, and 3 sub-checklists that feed into it. one about the benefits, who is intended to benefit, how easy is it for those intended benefits to be obtained. Flip side, compliance, who's required to take steps to comply, and some questions to ask about those. And very importantly, the institutions checklist, asking if we actually have in place the institutions, the user interfaces that will now enable people to interact with the legislation and will enable behavior to change in the way that we aspire to. There's lots more stuff in the book. I don't have time to talk about it now. I'm sorry. And then there's other things you could read, which I suggest in the book and on the slide, which are really, really helpful, I think, for legal designers. I've got an essential reading list and a strongly recommended reading list in the book. I've gone way over time. I should stop. Thank you very much. I hope that was useful. Ian, back to you belatedly.
Thank you, Judge. That was absolutely fantastic. That was a masterclass and plenty to look at there. Now, members of the audience, I know you're not shy. These webinars are, of course, recorded and in the public domain, but your identity and the questions attributed to your identity won't be, nor is the chat. So feel free in that context to ask questions of the judge. Some of you already have. And the first question, Judge, thank you for agreeing in advance to take questions. This is quite a long one, but I think a distilled read is that a lot of laws, and I think you pointed to this as well, are kind of largely hypothetical and experimental before the rubber hits the road. And there's less of an opportunity to beta test them. I know in the book you talk about effectively kind of trial periods, and I think implicitly sunset clauses to see how things work. I think the question here is really pointing to, is there a way that enables us to respond to these before they kind of coalesce and get into bigger macro failures, you know, cobras writ large with rats everywhere?
I think if you had cobras and rats together, at least the cobras might eat the rat. I don't might solve the other, but the two wrongs make a right answer is not usually one that it's good to try on a minister, I find, based on my experience. I think that we should be more open to pilots than we are now. I think that often, in fact, we're legislating against the backdrop of an existing legal regime, and we have seen it play out, and what we're doing is adjusting it in some respects. So the world we live in now is to some extent our sandbox. And of course, the whole point of comparative work, which is incredibly important when you're developing legislation, looking to other similar societies to see what they have done, if you do it well, is to say, well, what have they done there? Has it worked there? A question we must always ask. And how readily can we transplant it into our society? And that will, all of those things shine some light on whether a particular legislative framework will work for us in New Zealand here and now. But we are never going to be sure of that. This is the point of the question, I think, that laws are largely hypothetical and experimental before they come into force. Because by definition, it hasn't been the law in New Zealand before. It hasn't been implemented by our institutions before. And that's why I think adaptive legislation is the key. If you hardwire in primary legislation a solution that turns out to be unworkable, you've got a big problem. We can solve that in New Zealand faster than in some countries. Still slow, still expensive, still difficult. If, on the other hand, you have some principles and some frameworks in the primary legislation, and the detailed settings are in delegated legislation or are controlled by an agency that can provide guidance on them, then, like the triple CFA example, you can fix it within a reasonable time frame. So the big answer here is be modest about what we know, be modest about what we can predict, be cautious about putting stuff in primary legislation if we're not close to 100% sure it's the right setting.
And I think broadly, and dovetailing from that, thank you, Judge, is the broad church of partners, and this is really the next question on the docket, as it were, is not just policy and operations, critical integral relationship, monitoring, evaluation, others to see how the law is implemented properly, to see that it is implemented properly, but to see that it is created properly. Lots of people around the table, and again, something you touch on in the book, I think.
Yeah, I couldn't agree more strongly. Basically, not only do you need to design in a way that pays attention to implementation, But if you're going to have adaptive legislation that works, you need to design in a way that will enable you to capture information about how it's playing out in practice. And that needs to be a design feature of the regime. And then, and only then, is it possible to do systematic review? Experienced teachers, that it's easy to say, of course, we're going to need to monitor how this plays out as it goes on. And everyone says, yes, monitoring is terribly important. We'll do a review in 5 years or whatever. Mostly doesn't happen. And New Zealand's not alone in that. Whereas if you have structural mechanisms for capturing rich information about how a regime is playing out, and that's increasingly possible given ICT tools, then you have some chance of actually understanding what's going on and responding.
Thank you, Judge. We find ourselves at the top of the hour, so a huge thanks to you, Judge, and to you, members of the audience, for being there and participating. As I know that you have been, you will be able to watch this on a recorded version on the GREG website. So wherever and whenever you have found us, you've been very welcome here. I close, as I often do, with the MB Karakia, and I do so now. Ka hiki te tapu ke wātiai, te ara kia turukiai, te o marama, huiei, taikiai. Thank you very much again, Justice Goddard and members of the audience. And until perhaps next time, stay safe, stay well, and ka kite anō.